watching news at Prime. Let's get into another important conversation. The ATM party and its parliamentary leader, Vuyo Zungula, have filed an urgent application in the Constitutional Court. This is to appeal the Western Cape High Court judgment, which granted President Ramaphosa an interim interdict, halting the impeachment committee pending the outcome of his review application. The matter relates to the 2020 theft of foreign currency from the President's Phala farm. Let's speak now to the ATM's Vuyo Zungula, who joins me via the virtual platform. Mr. Zungula, it's good to talk to you. Thank you very much for your time. I'm glancing down because I want to quote some of what the court has had to say here, because in your submission to the Constitutional Court, you are saying that this decision of the Western Cape High Court is in conflict with the Constitution, and that the reasons, though, that you provide is that this matter is unconstitutional. However, the court itself is arguing that the rule of law must be upheld, and therefore ensuring that Parliament upholds same as it undertakes this impeachment process. It is necessary, therefore, to halt the work of these impeachment proceedings in order for that review application to be finalized. Is that not a reasonable ask?
Not at all. The reason why we are saying that order is unconstitutional, start from Section 1 of the Constitution, 1C, where it speaks about the rule of law, and the ruling on Friday, or the order on Friday, kusaqalwa nje, it is vague. Vague in the sense that the president, in his notice of motion, what he was asking for in the court was a suspension or a halt on the impeachment proceedings as a whole. However, the court order on Friday that was handed down on Friday is saying that the relief that was granted, it is the suspension of the public impeachment hearings. Those are two separate issues, which creates a vague situation whereby on Wednesday there could be Party A that says we must proceed, Party B or the chairperson of the committee can say we must not proceed. So it creates then a situation whereby there is no legal certainty, because for the rule of law to reign supreme, there must be legal certainty. The court orders that are issued must not be open to different interpretation or interpretation so difficult to make it as if it cannot be enforceable. Yeah. The second issue is that when it comes to the previous instances whereby interim orders or interim interdicts were actually granted, the Constitutional Court in the case of Godan 5812 in 2012 was very clear to say for any court order or interdict that impacts the functioning of a state functionary, it is imperative for the court to peek into the prospects of success of the main review application. In this particular case, there is no comment, there is nothing that speaks to the prospects of success for the review application that be held in September. That is in contradiction to what the Concord ruled in 2012 when it guides court as to a court then that grants an interim relief that will impact a state functionary. It is a requirement that it must peek into, or it must comment, or it must give a view on what are the possible or probable prospects of success for the main review application. That judgment on Friday did not touch on any of that. So if you were to look then at all of these, you would understand that the order in itself places Parliament in a crisis. One, what happens on Wednesday? And what happens between Wednesday and the time the matter is heard? Secondly, it is in conflict to an established principle that once you have a review, do not just give an interdict and not touch on the probable or possible prospects of success for that review.
Okay. I'll come back to Parliament or the processes of this committee in a moment. You have made comparisons, not once, but I believe twice now, particularly on this channel. You've made comparisons between the impeached public protector, Busisiwe Mkhwebane, her application for interdict, and you've made that comparison to what the president is seeking to do now, which he has been successful at. Here's a key difference, Mr. Zungula, and that is that the National Assembly, or should we say the Constitutional Court, rather, had already validated the rules by which the National Assembly would have had to play, given that process a thumbs up. Surely these two cannot be equated as one and the same thing.
Well, if you're to read the papers of the president when he was applying for the interdict, his main argument there was that the process, which is the impeachment process, has got the possibility of humiliating him, impugning on his dignity, etc. Now, based on two previous Western Cape High Court judgments on the issues pertaining to an office bearer wanting to protect his dignity when they are subjected to impeachment, the courts, the very same High Court of the Western Cape back then, clearly ruled that once you are a holder of a public office, you being held accountable in a form of an impeachment comes with that particular office. Therefore, it cannot be that you are going to have a Mr. Ramaphosa, because here we're not dealing with the office of the president, because he's not impeached or part of an impeachment process because of the office of the president and the functions of the president. He is subject to impeachment because the individual that is occupying that office may have committed misconduct and may have seriously violated the Constitution. And that is, it is nothing that is contradicting, or it is not really consistent, because the principle there was an office bearer using dignity, using so-called humiliation as a means of escaping accountability. Now, the courts on two separate occasions, two different sets of judges, and it was a full bench on two separate occasions. Both occasions, they ruled that accountability and the need for Parliament to fulfill its constitutional obligation trumps the so-called dignity of the office bearer. Now, two judges last week ruled against what those previous two judgments actually gave us.
Yeah. Let's deal with what you, in part, are arguing in your case to the Constitutional Court now, Mr. Zungula, and that is that, quote unquote, courts must stay in their lane. Here's a simple question for everyone to follow. Let's assume for a moment that the president, as you want it now, is taken through this impeachment process, and all of what he fears is going to be done, which is, to use your words, humiliate him. It is done. Only for the review application, which is going to happen in September, it comes back and says the report, the Section 89 report that was produced, is invalidated, but the president has already lost his dignity, as you argue. How would you reverse such a scenario?
There is no dignity of the president that will be impugned in that particular process, because since 2022 December, the report of the independent panel has been in the public domain since then, and either through questions, written questions to Parliament, or oral questions to Parliament, or even in debates, the president or us as members of Parliament, we have been making commentary on that particular report and all the details pertaining to Phala even then, and he has never said he's suffered when it comes to his dignity. The second issue that we need to really stress here is that portfolio committees of Parliament always ensure that the office bearers, whether it is ministers or anyone, is held to account. Recently, Senzo Mchunu was part of the ad hoc committee. And when he was there, he was asked questions pertaining to each and everything that he would have done in his capacity as a minister. Now, it cannot be then that when it comes to President Ramaphosa, then now the tune must change to say, what if he gets to be humiliated? Because, all I can tell you now, it means each and every public office bearer, whether it is a public protector, head of a Chapter 9 institution, minister, or mayor, can easily say, I'm not going to subject myself to a parliamentary process because I fear that I may be humiliated. There's no humiliation, firstly, when you are subjected to a constitutional process of accountability, because Section 42(3) of the Constitution is very clear. Parliament, the National Assembly, is obligated to scrutinize, and this committee is set out to do exactly that, to scrutinize the action of Mr. Ramaphosa in relation to Phala. Lastly, the president has always maintained he's acted lawfully. There's nothing illegal or unethical that is done. Therefore, where could humiliation come from when he's given a platform to dispel all of the mistruths, all of the lies that may be peddled in the past couple of years, because he's never had an opportunity to say to South Africans, you Zungula, you are lying when you're saying 1, 2, 3. You so-and-so, it is a lie when you're saying 1, 2, 3. This particular process will give him exactly that platform. So the people here that could be humiliated, it is perhaps me, it is us, because he's going to speak the truth and dispel all of the lies perhaps we may have been peddling, if that is the case.
Yeah. Here's another crucial question, Mr. Zungula, and that is that interim interdicts are generally not appealable and can only be heard in instances where it is in the interest of justice or indeed exceptional circumstances exist. How do you plan to persuade the Constitutional Court around this, particularly for direct access? Because it's not automatic that your matter is going to be taken on board. The court has to pronounce itself as to whether or not this case does deserve their attention.
Firstly, there is precedence in the National Assembly versus Outer, where there was an interim interdict that was set aside by the Constitutional Court. So, firstly, it is not a new thing. The second thing is that this particular interim interdict, it is appealable because it has a binding effect. It has a binding effect and it creates precedence in the sense that whenever now there's going to be any discussion or any issues pertaining to the halting of impeachment processes, now people are going to quote this particular judgment to say, this particular judgment ruled that 1, 2, 3 must happen, or a person who's protecting his dignity or fears humiliation can have, can be granted an interdict for the impeachment process to be halted if you make that application. Now, because again, there is no court that will sit to determine whether the interdict granted last week was lawful or was not lawful. It clearly shows how the interdict, it is an interdict that is binding, because the review application, as it says in that order, that the interdict stands up until the finalization of that review application, only means the court in September are not going to look at the reasons that were tabled to grant this particular interdict and whether those reasons are actually correct in law. That is why it becomes important for us as Parliament to go to court for legal certainty, because again, there's conflicting or contradicting judgments. The public protector, and in 2 separate occasions, there's a judgment that goes that turned her down when it comes to halting an impeachment process on the grounds of reputation. But this one actually did so. It granted the interdict. So the interdict that was granted last week is binding, it creates precedence, and most importantly, there is no court that is set out now to ascertain whether the legal precedence that would be set by this particular judgment, whether it was correct or not. And it becomes important, especially in the light that it was not a unanimous decision by those 3 judges. Therefore, you can't have a decision taken by a majority, not by unanimous decision, creating precedence in terms of the law. Rather, have the highest court in the land have that obligation to do so.
Very two quick questions before I let you go. The head of the impeachment committee, Mahashule Gana, he is clear that he has studied the judgment in full and has consulted with the legal team as well. And he's confident that the preparatory work of the committee will continue and that this is going to be what becomes part of Wednesday's meeting. Surely the work of the committee continues then.
Yeah, that is what perhaps he's saying. However, the ANC released a statement last Friday. In their understanding, the work of the impeachment committee at all is going to be halted. This is where it probably becomes very important. You can't then have a judgment that is open to interpretation by the people basically who are part of how they need to comply with that particular court order. Because I'm sure in this particular station, you've been hearing views from legal analysts who one says this, the judgment means this, another one says it means that. That on its own is the clearest indication why this process by us as ATM must actually be embarked on and supported, so that you don't find on Wednesday having parliamentarians, MPs, members of the committee, then having to debate on something that should be clear, because the court order should be clear to say X, Y, Z must happen. Yeah. Not have a case whereby now we're going to debate and discuss, this is what we view, and then hand it over to the legal advisors of Parliament, and then be uncertain legally as to how we should proceed. And the other issue, which is very, very important here, the court order there, remember the application by the president says he wants the impeachment process to be halted. The court order says it is granted that the public impeachment hearing are halted. Now, the issue there is that Parliament, in terms of Section 59 of the Constitution, it is spelled out in the Constitution that it must conduct its affairs in a manner that is open to the public. Meaning, if one can read that order, it suggests that, fine, we can have an impeachment on President Ramaphosa, however, it must not be in public. That is the clearest violation of Section 59 of the Constitution. So what we want by approaching the Concord is for legal certainty. We do not want a case whereby a court order that must be abided to by Parliament is open to different interpretations. And at the same time, we're heavily guarding against any court order that comes from any court that seems to be inconsistent with the provisions of the Constitution.
Final question to you, sir, and it is completely unrelated. We are running a breaking news strap as we speak. The head of IDEC, Andrea Johnson, we have it on good authority on this station that she has written to the NDPP, and the understanding is that the NDPP, Ndimotibi, is now considering a letter, this letter from Andrea Johnson, where she is asking for permission to resign. How do you react to that as a member of Parliament who has sat in committees to do with matters of law enforcement?
With law enforcement, it is very critical that all of the people that occupying the positions of power in law enforcement institutions must be people that are ethical, people that give confidence that they do their work without fear or favor or any form of prejudice. Therefore, with the testimony that Ms. Johnson actually provided in the commission, particularly how there seems to be some level of prejudice against one of the people that were in law enforcement, clearly shows that she's not a person that should have occupied that position, because you can't then have a head of IDEC being a person that would be viewed as a person that does not follow the law, but follows something else which is not in the interest of the law. So we're hoping that that resignation will get to be quickly accepted, and most importantly, a credible individual that is all about retaining the integrity and trust to the office dealing with IDEC and law enforcement is going to be appointed, so that when we speak about law and order in our country, we do not then have to bite our teeth because the people that are at the helm of such institutions are themselves of questionable conduct.
Vuyo Zungula, thank you very much for your time. Member of Parliament belonging to the African Transformation Movement. And just to be clear on the reporting lines here, the understanding is that Andrea Johnson, because she runs an agency that sits below the NPA, the head of the NPA would then become her immediate boss. And so that letter would possibly have gone to Andy Motibi, but the appointing authority is the president. And so that letter surely would also have landed on the desk of the president. We're going to have to await and hear what the finality is on this one. Okay, when we